Greetings and welcome to Constitutional Law, Declaratory Judgments, and Constitutionality of Statutes. To start with, we're going to get right down to the time, place, and manner of raising constitutional questions generally. And of course, before we get into it, just to remind everyone, this is for educational entertainment purposes only, not to be used for your professional, personal, business, or legal affairs. Don't do this at home. Let's continue. So we're starting with Section 128 of 16 AmJur, Second Edition Constitutional Law, and time, place, and manner of raising constitutional questions generally. It has been held that a challenge to the constitutionality of a statute may be raised at any time. However, it has also been held that one whose rights are allegedly invaded by an act of Congress, a state legislature, or an administrative board must raise his or her objection at the earliest available opportunity. So let's see what these references are here real quick. It's 2006 and 1995, 62, 65, and 2011. As to a waiver of constitutional argument by failing to raise it at the earliest opportunity, see Section 161. That's where we may get into estoppel of latches there too, but let's continue. So, let's see, where do we leave off here? However, it's also been held that one whose rights are allegedly invaded by an act of Congress, a state legislature, or an administrative board must raise his or her objection at the earliest available opportunity, consistent with good pleading and orderly procedure, and must exhaust any remedies which may have been provided for the correction of unreasonable and improper orders before he or she will be permitted to make an attack in the courts on the constitutionality of the statute or regulation. He or she must also raise the constitutional issue in a proper manner. Even where a constitutional question is presented, a litigant must ordinarily follow statutorily prescribed remedies. So let's read into this a little bit more, because on its face it seems a bit prohibitive, but in a way you got to see that it says that it must exhaust any remedies which may have been provided for the correction of unreasonable and improper orders before he or she will be permitted to make an attack in the courts on the constitutionality of the statute or regulation. So important here is to look at any remedies which may have been provided, right, for the correction of unreasonable and improper orders. So there have to be remedies for the correction of unreasonable and improper orders, right? And if you've exhausted those remedies, only then we'd be permitted to make an attack in the courts on the constitutionality. So look at the order of things that must be addressed in this priority here. Let's continue. As it says here, he or she must also raise a constitutional issue in a proper manner. So they're looking for statutorily prescribed remedies, because if they're not followed, then that's always going to be the reason that the remedies were there. And that's one reason why the litigant must ordinarily follow the statutorily prescribed remedies. Usually, a court will not inquire into the constitutional issues on its own motion. A judge's sua sponte, so the judge on his own order here of the court, declaration of unconstitutionality is a degradation of the strong presumption of constitutionality according legislative enactments. The courts have generally taken the view that a judge, even though it is the judge's duty to interpret the laws, cannot, in a proceeding, to compel the performance of some ministerial duty on the judge's part, initiate the objection that a statute is unconstitutional where the judge has no personal interest involved and the judge's duty does not require the judge to raise such a defense. So this is densely packed here in this sentence. Let's reread this here. The courts have in general, this is their presumption, so to speak. They've taken the view that a judge, even though it's his duty to interpret the laws, cannot, in a proceeding, to compel the performance of some ministerial duty, right? Not judicial, but a ministerial duty on the judge's part. In a proceeding to compel the performance of some ministerial duty on the judge's part, right? So let's follow this. The courts, that even though it's his duty to interpret the laws, right, that a judge cannot, in a proceeding to compel the performance of some ministerial duty on his part, initiate the objection. So the objection has to be done by one of the litigants here. So the judge, it's just generally taking the view it's not his duty to initiate the objection in a statute. That a statute is unconstitutional where the judge has no personal interest. Of course, that would be, a reason for recusing the judge involved in the judge's duty. Does not require the judge to raise such defense. Again, this would be up to the litigant to bring this point up of constitutionality, and that the judges, typically on their own accord here, are not going to make that declaration. All right. So, however, such a course is appropriate where the constitutional question, not raised until it was suggested by the appellate court, goes to the jurisdiction of the court below to entertain the proceedings in which the orders appealed from were entered. So it's not until it's raised by the appellate court that it goes to the jurisdiction of the court. So as you see here, the way they've prescribed remedies is to go through an appellate process. That way that is the time the jurisdiction of the court below is to be entertained. So, interesting perspective. Not that this is the way things must be done. This is generally speaking how things have been. And we have, let's see, let me check the chat here real quick. And the original gangsta says, I have a judge that is acting in bad faith and is unbecoming. It depends on what you mean by the bad faith in what areas. And in that case, you would have to put that onto the record, I would assume, so that you can have a grounds for an appeal later. But every case is different. And of course, I wouldn't be the one to get legal advice from here. I'm just on YouTube. Let's continue. All right. So let's see here. So again, this is up to the appellate courts to look at the jurisdiction of the court below, that bringing that up at the time of hearing, as we saw even here before in the introduction here, that it may be raised at any time. However, it has also been held that one whose rights are allegedly invaded by an act of Congress, state legislature, or administrative board must raise his or her objection. See this? An objection at the earliest available opportunity. And this is part of your prescribed remedy in a proper manner. Your objection at the earliest available opportunity. And here's a case citation. Will be several of them to substantiate that. So this is why you would bring it up and why you want the court to acknowledge it as soon as you bring up this objection, because you want the court to be aware you're doing this at your earliest available opportunity, because this is the time and the place and the manner of raising your constitutional questions. So I hope this is starting to make sense here, because it's a lot of words. However, it's starting to bring in a clear picture of why we do things in a certain way in these courts in order to get results. An interested party may, in general, attack the presumption of the constitutionality of a statute whenever such is material to the case, and the statute has been applied or is about to be applied to deprive him or her of a constitutionally protected right. This is ordinarily done by demurrer, motion, plea, or other objection, as we read before, of some kind, made in the trial court wherein the statute or ordinance is sought to be applied. Once again, this is giving us the practical application here. This is ordinarily done by demurrer, motion, plea, or other objection of some kind. Remember the objection, earliest as possible, made in the trial court wherein the statute or ordinance is sought to be applied. When a party challenges the constitutionality of a statute as applied to a specific set of facts, right? We're looking at the statute as applied. Statute. This is key here. As applied, verb here, to a specific set of facts. A record is required. When a party challenges that constitutionality, a record is required. The proponent of the constitutionality of a statute also needs notice and an opportunity to develop an evidentiary record to support that view. So, this I think is also leading the way to evidentiary hearings and further proceedings. Let's continue on here and read some of these footnotes here. All right, we had number 11. Okay, yeah, so these are all cases. These are all citations of cases to look into. 16 is a suit against an officer is a classical method of testing the constitutionality of the statute under which the officers purport to act. This is 1944. So let's get back here. So the important part here is that opportunity to develop an evidentiary record to support the view of the constitutionality. This goes both ways when a party challenges that constitutionality. The types of legal proceedings in which constitutional questions may be raised are, for all practical purposes, limitless. In proper cases, the constitutionality of a statute may be tested by an action for declaratory relief, and constitutional issues may also be litigated in various actions at law, including contract and tort suits. Suits to recover paid taxes provide another frequent means of litigating constitutional issues. Reminds me of Orlando Steve there. Let's see here, number 20. Yeah, so we have some really nice citations here to look at. Cleveland Surgery Center. Let's see, I guess that's Ohio. All right, let's get back here. Yeah, let's check on the chat here. All right, we got Original Gangsta has mentioned. Okay, we got to look at it from here. I'll read it out. The Supreme Court gave me the application for writ of certiorari forma pauperis for my civil small claims case. The judge has dismissed case with prejudice, failure to follow rules of court. Yeah, I guess there's a lot more details to look into that, but that sounds typically what they try to do. Again, this is why not to encourage, the religious adherence to all their procedural requests and guidelines. There are, however, some advantages to following that and extinguishing and exhausting all the prescribed remedies to get right down to the cut to the chase, so to speak. All right, well, let's continue on here. So there's a few words here that I want to make sure everyone understands and knows. So we have some ways of having the statute that's being applied to deprive someone of their constitutionally protected right. And when this is done in the case, early on, we want to have this addressed. And this is done by a demurrer, a motion, a plea, or an objection of some kind made in that trial court. Let's look up the word demurrer in the Black's Law Dictionary, because this way we make sure people are very clear on the meaning of this particular term, because this is an action that has been recommended to take. And before we get there, let's just let everyone know we're looking at Black's Law 9th edition, and we're going to look for demurrer. Unfortunately, this is oh wow, it's going to stay here. This would be great. It's a scanned document, searches poorly, so patience is appreciated here. Demurrer. Hey, what do you know? This is just miraculous here. Demurrer. This is law French. Demurrer, to wait or stay. 16th century. A pleading stating that although the facts alleged in a complaint may be true, they are insufficient for the plaintiff to state a claim for relief and for the defendant to frame an answer. In most jurisdictions, such a pleading is now termed a motion to dismiss. So it's a fancy word for motion to dismiss. But demurrer is still used in a few states, including California, Nebraska, and Pennsylvania. So let's read further. The word demurrer, derived from the Latin demurrari, or the French demurrer, meaning to stay, wait, or stay, imports that the party demurring waits or stays in his proceedings in the action until the judgment of the court is given whether he is bound to answer to so insufficient a pleading. Each party may demur to what he deems an insufficient pleading of the other. The demurrer was general when it was to matter of substance. It was special when it is made to matter of form, and must specifically point out the defect. See, Edwin E. Bryant, The Law of Pleading under the Codes of Civil Procedure, 1899. So we have the general demurrer. The parole demurrer is a suspension of proceedings during the minority of an infant. Speaking demurrer, 18th century demurrer that cannot be sustained because it introduces new facts not contained in the complaint. Special demurrer, a demurrer that states grounds for an objection and specifically identifies the nature of the defect, such as that the pleading violates the rules of pleading or practice. So this is about form. If a pleading is defective in form but not substance, a defect must be pointed out by special demurrer. So this is when you're the grammar Nazi. I get it. But it would still work. Demurrer to evidence. A party's objection or exception that the evidence is legally sufficient to make a case. So when you object to the legality of the evidence, its effect upon joinder in the demurrer by the opposite party is that the jury is discharged and the demurrer is entered on record and decided by the court. A demurrer to evidence admits the truth of all the evidence and the legal deductions from that evidence. Wow. So demurrer to interrogatory is the objection or reason given by a witness for failing to answer an interrogatory. Interesting again. So quite a few ways of looking at demurrer, and it is a important term to know. And again, motion to dismiss in a general sense is what it's been interpreted as. However, some states will still use that term. All right, let's get back to the book here, and let's continue. So, let's see. The usual method of review of a lower court's determination of a constitutional issue is by appeal, and other forms of review are not ordinarily available where an appeal may be taken. However, after an appeal to the highest state court, if the issue involves the federal Constitution, the defendant may appeal directly to the United States Supreme Court, since no further review is available to him or her within the state. Generally speaking, an intent to violate a state law is not relevant to determining standing, but a potential criminal liability as a result of such a violation is relevant to confer standing. Under the federal Constitution and most state constitutions, standing to challenge the constitutionality of a statute or regulation requires a justiciable controversy and a real and immediate threat of injury. Okay, so they got me on this one. Okay, we gotta look this one up. All right, just bear with me because we're just taking a scan document here, hoping it's going to get us to where we need to be here. All right, almost there. It's catching up. All right, now it's going. But we're at the ends of the J, so I got to jump a little bit more here. Okay, here we go. Okay. Justiciable, or whatever that was. All right, it should be close to it now. All right, juice. Okay. I, right? CI. Here it is. All right, justiciability. Justiciability. All right, justiciability. Or justiciability. Okay, so we're going to say it properly. I mean, the thing is here, it's like vegetable. Justiciability. The quality, this is 15th century, so I guess that's, I'll give me some permission here for not knowing the pronunciation. The quality or state of being appropriate or suitable for adjudication by a court. See mootness, doctrine, rightness, standing. Concepts of justiciability have been developed to identify appropriate occasions for judicial action. The central concepts often are elaborated into more specific categories of justiciability: advisory opinions, feigned and collusive cases, standing, ripeness, mootness, political questions, and administrative questions. Now, this is nice. 1984, Federal Practice and Procedures, 2nd edition. So, justiciable. Properly brought before a court of justice, capable of being disposed of judicially. All right, so a great word to use, justiciability. All right, let's get back to the book. Under federal constitution and most state constitutions, standing to challenge the constitutionality of a statute or regulation requires a justiciable controversy, one that can be handled in that court, right, with standing and rightness, and a real and immediate threat of injury. All right, beautiful. This is as to waiver of constitutional agreement by failing to raise it at earliest opportunity. We came over that one already. As presumption of constitutionality of legislation, we see section 165, and a suit against an officer, we read that one, and we're done with that section. That was a pretty intense section there. Time, place, and manner, of course, is essential. So now we're on to the next section. Before we do that, let's check on the chat here. All right, we have here Diesel for We the People. Give me a second here. I pull this up here. Interesting question. Instead of ejecting, do I deny your claim? It would depend, I guess, on the situation, of course. As you see, there's different ways of addressing this. There's, all the ones we just went over there as far as justiciability. It says here from the original Gangsta, the judge was a grammar critic and failure to grant my answer a motion to their motion. So you would answer to their demurrer of, what was that particular demurrer we just mentioned? That would be a good way to look at it because it was a form and you would have a correction according to that implied demurrer of the judge. I don't know, that might be one way to look at it. St. Frog Dog says that the judge involved in my case refused to prove jurisdiction, then found me not guilty for that license BS. Well, if you're found not guilty, then when I say judge, I mean she refused to force the prosecutor to prove it. Oh. But if they found you not guilty, then I guess they avoided having that on the record, as we saw before. To bring in that constitutional case forward, you need to have this onto the record. And of course, that's the last thing they're going to want to have is something like this on the record, I would assume. All right. So let's get back to the presentation here. So we're on to section 129, direct or collateral attack on constitutionality of statute. Actions attacking the validity of a statute or ordinance generally must be brought by a direct suit for that purpose, rather than by a collateral attack in order to ensure due process of law. So, this had to be its own action. Thus, insofar as a university's action in eliminating its men's swimming program while retaining its women's swimming program were taken in an attempt to comply with federal civil rights laws, an equal protection attack on those actions by members of men's swimming team was merely a collateral attack on the statute and its regulations, and was therefore impermissible. Normally, a failure to raise a constitutional issue on direct appeal will bar raising the issue in a collateral attack. All right. However, the constitutional claims can be raised for the first time in a collateral attack if a defendant can demonstrate a cause for the procedural default, as well as actual prejudice from the failure to appeal. Collateral attacks on matters occurring in a foreign nation legitimately may be barred by treaty. If a direct appeal or other avenue of collateral attack is created by a state, it must conform to due process standards. There is no constitutionality enshrined right to mount a collateral attack on a state's court's judgments in the inferior Article 3 federal courts. A fortiori, there is no mandate that state court judgments embracing questionable or even erroneous interpretations of the federal Constitution be reviewed by the inferior Article 3 courts. Wow. So let's see, this is referenced by footnote 7. Judgment, this is 1997-96. So this would be an interesting case to look up in the 7th Circuit. You have your cases right here. You can check that out. And on footnote 1, we have where a plaintiff attacks a zoning ordinance as confiscatory and unconstitutional, relief is afforded by means of a direct attack upon the terms of the ordinance. And an application for a variance is not a condition precedent to a judicial remedy. So where a plaintiff attacks a zoning ordinance as confiscatory and unconstitutional, the relief is afforded by means of the direct attack of that unconstitutionality, the terms of the ordinance, and the application for a variance. So you're not asking them to correct it. You're just saying that that ordinance is unconstitutional and confiscatory with a direct attack, not a collateral attack, saying I made an application and I was denied because it was unconstitutional. You see? That's what they're alluding to here. At least this is from this case in 1960 that could be referred to in the village of Scarsdale. This is in New York district. So let's continue on from there, on to section 130, raising constitutionality of statute for first time on appeal. And before we get to this, let me make sure we're all caught up in chat. All right, let's see what we got here. I think we're all good here. I think I saw another one here from Original Gangster. I don't know if we got this one or not. The defense attorney's demurrer was exceptional because of the time to file on time and failed to request an extension. Right. So the special demurrer is when it's with form, and the exceptional because of the time. Well, I mean, you'd have to rebut that with some kind of justification, I would assume. But that's, I guess that would depend on details. That being said, let's get back to the document here. So we're on to section 130, the constitutionality, raising it for the first time appeal. An appellate court may raise the issue of a statute's constitutionality sua sponte. But the appellate court may raise the issue, but on their own accord, but that seems pretty rare. The constitutionality of a statute cannot be raised for the first time upon a rehearing in a civil case. Ooh. Wow, the constitutionality of a statute cannot be raised for the first time upon a rehearing in a civil case. Let me see this one here before we get to the practice tip. That's footnote 2. That's 1952 and 1925. Okay, so it's long-standing. Let's read the practice tip here. The United States Supreme Court does not have the power to consider whether a particular part of a state statute violates the federal Constitution. In an appeal from a state criminal conviction where the constitutional question was not presented at the state courts in such a manner that it was necessarily determined by the state's highest court when it affirmed the conviction. On such an appeal, it will be assumed that the failure of the highest court to pass upon a federal question was due to lack of proper presentation in the state court, unless the contrary is affirmatively known. No particular form of presentation is required to draw the validity of a state statute in a question before the state court, so as to give the United States Supreme Court jurisdiction to review an adverse decision, it being sufficient if the claim of invalidity and the ground thereof are brought to the attention of the state court. So, again, it's a matter of bringing that constitutionality, right? Not during a rehearing of a case. So before a case you would ask for a rehearing, it would be more proper to take that appeal on that constitutionality before a rehearing. It seems, from what I'm reading here, with a federal court system standing, whether constitutional or prudential, is a jurisdictional issue which cannot be waived or conceded. Thus, a federal court of appeals is bound to conduct an independent inquiry as to the plaintiff's standing to challenge federal laws and regulations, even though the defendants have not challenged and the district court has not ruled on the standing issue. Ooh, interesting here. That's the Animal Legal Defense Fund, and that was 1994 in the D.C. Circuit. All right. So now we're on to the declaratory judgment as to constitutionality of statute. And let's double check onto our chat here and see if there's anything else that we've missed at this point. Double check on, make sure this is being updated on the chat, because I found that often it'll just stall. But it looks like we're up. And let's continue. So, declaratory judgment actions have often been utilized to test the constitutionality of statutes and governmental practices. The Uniform Declaratory Judgments Act makes specific provision for the determination of the construction or validity of state statutes and municipal ordinances by declaratory judgment, and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of statutes and ordinances. A challenge to the constitutionality of a statute based on the provisions of a state constitution present a justiciable controversy and a declaratory judgment action. In addition, the federal declaratory judgment power has been invoked frequently as a means of testing the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either a federal or state statute by a single federal judge, so long as he or she does not ask to have the operation of the statute enjoined. A court may not grant declaratory relief unless there is a case or controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base an adjudication. Let's contrast that from where we were before about the taking the appeal before a rehearing, right? So let's continue on from here. A mere difference of opinion as to the constitutionality of legislation does not afford a basis for declaratory relief. Thus, a declaration construing a statute or ordinance and determining its validity will be made only where there is an actual controversy between the parties, requiring the determination of this question. The Supreme Court is concerned with cases and controversies in reviewing declaratory judgment actions from both the state and lower federal courts, so long as a legislation authorizing declaratory judgments and the practice of the courts restrict judicial action thereunder to cases and controversies. So actually what I was referring to here about the case and controversy is the collateral claims, that you wouldn't want to have a collateral claim saying that you went to have a zoning variance and then it was denied, so you went to make a collateral case against the constitutionality. Wouldn't be the appropriate way of doing it. You wouldn't want to have them join in such a way. So the best thing is to have its own case or controversy strictly about the constitutionality. Now, in this case, we're talking about a court may not grant declaratory relief. We're talking about specifically the declaratory relief now. And if declaratory relief is involved, there must be a case or controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base adjudication. So this is quite different, as we're reading here, as for a declaratory judgment, as opposed to what we're reading here about basically just raising the constitutionality of statute for first time on appeal. So a declaratory judgment as opposed to an appeal is what we're comparing here. So on section 131 is declaratory judgment, and let's continue. All right, let's see here. I'm trying to get where we left off here. A court may not grant declaratory relief unless there is a case or controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base the adjudication. A mere difference of opinion as to the constitutionality of legislation does not afford a basis for declaratory relief. Thus, a declaration construing a statute or ordinance and determining its validity will be made only where there is an actual controversy between the parties requiring the determination of this question. The Supreme Court is concerned with cases and controversies in reviewing declaratory judgment actions from both the state and the lower federal courts, so long as legislation authorizing declaratory judgments and the practice of the courts restrict judicial action thereunder to cases and controversies. So the Supreme Court is concerned with the cases and controversies. Not necessarily that constitutionality aspect of it, it seems. That's for the appeal. And then after that, hmm. So, although courts have, under particular circumstances, entered declaratory judgments as to the validity of statutes, notwithstanding the apparent absence of a justiciable controversy, no such declaration will ordinarily be made in the absence of such an actual controversy. Thus, if one seeks a declaration in a civil suit as to the unconstitutionality of a statute under which he or she was convicted, and if the suit is brought out of merely academic curiosity about the constitutionality of the statute, then the kind of interest in the outcome of a suit would support federal jurisdiction, consistently with the Article 3 of the Constitution, is lacking. So consistently with Article 3 of the Constitution. Let's read this again here. Thus, if one seeks a declaration in a civil suit as to the unconstitutionality of a statute under which he or she was convicted, and if the suit, so this if one seeks the declaration in a civil suit as to the unconstitutionality of a statute they were convicted, the suit was brought merely academic curiosity about the constitutionality, then the kind of interest in the outcome of the suit that would support federal jurisdiction consistent with Article 3 of the Constitution is lacking. So this is, I guess, a warning for declaration as the unconstitutionality if it's a merely academic curiosity about the constitutionality of a statute. Then the interest of a suit in federal jurisdiction would be lacking. And that comes from footnote 13, 1994, Reno. Okay, that was a pretty difficult wording to understand, but the style of writing is in that legal sense, and it's meant to be as detailed and specific as possible for the subject matter at hand. All right. Let's continue on here. Section 132, advisory opinion as to constitutionality of statute. Absent constitutional or statutory authorization, court has no power to render an advisory opinion. Thus, in most states, the courts will not give advisory opinions on constitutional or any other kinds of issues, not before the court, as cases or controversies. The rule is not changed by facts that the request for an advisory opinion is made by the governor or the state legislature, at least in those states where the courts flatly refuse to render such opinions. However, there is no such federal constitutional case or controversy clause applicable to the states, and thus states are free, as a matter of their own procedural laws, to determine whether their courts may issue advisory opinions or to determine matters that would not satisfy the more stringent requirements in federal courts that an actual case or controversy be presented for resolution. In a minority of states, the courts will render advisory opinions, although these usually are given only under rare circumstances and under certain conditions. For instance, in one state, the Supreme Court will render an advisory opinion only on narrow questions directed to specific provisions of the federal or state constitutions or on issues regarding the constitutionality of pending legislation. In another, the Supreme Judicial Court will render advisory opinions only on important questions of law and on solemn occasions. A state Supreme Court may also generally refrain from advising the governor on issues that do not have any bearing upon the present constitutional duty presently awaiting performance by the governor. Wow. Further, a court may not be authorized to render advisory opinions to private individuals or advisory opinions to private individuals. Further, a court may not be authorized to render advisory opinions to private individuals or regarding existing as opposed to proposed legislation. Under the United States Constitution, the judicial power of the federal courts is restricted to cases and controversies. Thus, federal courts are not authorized to issue advisory opinions under any circumstances. So, federal courts are not going to give you an advisory opinion. And case number 11 looks like an interesting one. Before we get to the observation, let's see what citation 11 is. Opinion of the Justices, 2015. Interesting. Okay. The exercise of judicial power under Article 3 of the Constitution depends on the existence of a case or controversy. So, under Article 3 of the Constitution, the judicial power depends on the existence of a case or controversy, and a federal court lacks power to render advisory opinions. The mere possibility that the defendant, who was self-proclaimed leader of an unrecognized Bosnian Serb entity called Srpska, might at some future date be recognized by the United States as the head of a state of a friendly nation, and might thereby acquire head of state immunity, did not transform the claims of the plaintiff Bosnian victims under the Alien Tort Claims Act and Torture Victim Protection Act into a non-justiciable request for an advisory opinion. Wow. Non-justiciable. Justiciable. All right. Let's get back to our observation here. A prior restraint on the exercise of First Amendment rights confers sufficient standing to challenge such statutes. You get that? A prior restraint on the exercise of First Amendment rights confers sufficient standing to challenge such statutes. And in such cases, plaintiffs need not show that an actual injury has already occurred in order to challenge statutes or regulations imposing a burden on the exercise of First Amendment rights, which ruling, in effect, permits courts to render opinions in the nature of advisory opinions in this one area. That's footnote 16. New Hampshire Right to Life Political Action Committee versus Gardner, and that was 1996. Cooper versus McBrath, C. Briggs versus Ohio's Elections Commission, 95. Anti-abortion protester, City of Colorado Springs, 95. The pre-enforcement nature of a lawsuit challenging a Virginia statute prohibiting the commercial display of sexual or sadomasochistic material harmful to juveniles did not prevent booksellers from having standing to maintain suit, where the state had not suggested that the newly enacted law would not be enforced. The bookseller had an actual well-formed fear that the law would be enforced against them, and alleged the danger was in large measure one of self-censorship, a harm which could be realized without an actual prosecution. That's a valid point. Certified question answered on the grounds. Parents, students, and a civil liberties organization had standing to challenge a state statute permitting public school students to initiate a non-sectarian, non-proselytizing prayer at various compulsory and non-compulsory school events, despite the fact that the statute had not yet been implemented. Wow. So they were challenging it before they implemented the statute. And they did have standing. So that's Jackson School District. What state is this? Fifth Circuit. All right. In the First Amendment arena, especially when there is a possibility that rather than risk punishment for conduct in a challenging statute, an individual will refrain from engaging further in a protected activity. Courts have been willing to relax prudential standing limitations and permit a third party to assert the rights of persons not otherwise before the court. Even in such situations, however, a court must still consider whether the third party has a sufficient injury, in fact, to satisfy the Article 3 case or controversy requirement. All right, and that's a 95 case there. A lot of supplements there for that area. But this is important to know that, we're talking about is the advisory opinion as to the constitutionality of a statute. And we're on to the next one, Section 133, the Pleadings, Briefs, and Argument on Constitutionality of Statute. And let's briefly take a look at the chat here. All right, I think we're all caught up here on the chat. And anyone else in there wants to pipe in the chat, just to let me know this is not stalled here and I'm getting feedback, that'd be great. Other than that, let us proceed. Okay, so we're on to the Pleadings, Briefs, and Argument on Constitutionality of Statute. Courts will not ordinarily pass upon constitutional questions which are not raised by the pleadings. However, in some cases, courts will review constitutional questions not raised by the pleadings in cases of plain error. An appellant who fails to argue a constitutional contention in his or her brief, merely setting it forth in one sentence, is considered to have abandoned or waived such contention. The United States Supreme Court has said that it will not consider a constitutional question that was neither raised nor briefed nor argued before it. Similar authority is to be found in the decisions of state courts. Although an act's unconstitutionality need not be pleaded with any greater definiteness or certainty than other issues, a party should, by proper averments, bring himself or herself within the scope of the act and show the feature of it, which would be injurious. The burden of raising a constitutional question is composed of three tiers. First of all, the plea of unconstitutionality must be made in the trial court. That's number one. Next, the plea of unconstitutionality must be specially pleaded. So specially, I believe, was in the manner of the form. Finally, the grounds outlining the basis of unconstitutionality must be particularized. The mere reference to a statute's constitutionality with nothing more does not meet the standard of persuasion required to mount an attack on constitutional grounds. These procedural rules exist to afford interested parties sufficient time to brief and prepare arguments defending the constitutionality of the challenged statute. This opportunity to fully brief and argue the issues provides the trial court with thoughtful and complete arguments relative to the issue of constitutionality, and furnishes reviewing courts with an adequate record upon which to adjudge the constitutionality of the statute. Absent authority and a reasoned analysis to support it, the mere assertion of unconstitutionality is insufficient to adequately raise a constitutional question. The court should not rule that a statute is unconstitutional as applied to a particular case until a complete record has been developed. A proper presentation of an alleged violation of the Constitution should include a discussion and an analysis of one or more of the following non-exclusive criteria. Here we go. Get out your clipboard and pen. Textual language, legislative history, pre-existing state law, structural differences, matters of particular state interest or local concern, state traditions, public attitudes. Now look at this. This is like an outline. This is a great little checklist here for an outline. Courts cannot be expected to search through the record in applicable case law to discover deprivations of a constitutional magnitude when the party attempting to claim a constitutional violation has not bothered to do so. So do your due diligence. Here we go. Practice tip. Failure to raise the issue of constitutionality of a statute below will normally preclude a court from considering the issue on appeal. But the court may sometimes decide to exercise its discretion to review an issue not raised below in exceptional cases or particular circumstances, or when the rule would produce a plain miscarriage of justice. And that's footnote 18. Let's go through these footnotes here, see if there's any extra notes here. The plaintiff's argument that a statute was unconstitutional as applied to them was waived when not raised in response to a motion to dismiss. The plaintiff's argument that a statute was unconstitutional as applied to them was waived when not raised in response to a motion to dismiss. Well, timing's everything in these cases, it seems. Constitutional questions will be dealt with only as they are appropriately raised upon a record before the court. Will only be dealt with as. So it seems to me that having a case on record before the court is what allows the constitutional questions to be dealt with. So by avoiding having the case on a record before a court, then they can skirt around having those constitutionality questions asked. The court will not rule on constitutional questions that are not precisely in issue, again to the particular nature of the pleadings, when the unconstitutionality of a statute is specially pled. The claim must be raised in a petition, exception, motion, or answer. It cannot be raised in a memorandum, opposition, or brief, as those documents do not constitute pleadings. So, this is great language to know, and again, this is just a matter of correctness in procedure to avoid nonsense later on. And it's a small little extra thing that we have to do, an effort, just to deal with the presumptions of us being incompetent, which we're typically not. I would say that everybody here tonight studying this along with me here would not be in that category of incompetence. However, some of the people you may be dealing with in these venues are. So by taking the road of full competence on your own accord, it puts you in a higher standing here. When the unconstitutionality of a statute is specially pled, the claim must be raised in here's what you would do, a petition, an exception, a motion, or answer. You wouldn't do a memorandum, opposition, or brief. To properly raise a constitutional challenge to a statute, the party attacking the statute must show three things. One, remember these: the statute or the particular parts of the statute which the party would challenge must be stated or pointed out with fair precision. Remember, so to give them a fair chance to answer to the constitutionality. Two, the provision of the Constitution which it is claimed has been violated must be clearly designated. And three, it must be shown wherein the statute or some designated part of it violates such constitutional provision that you mentioned in Section 2. And that's 2008. Oh, yikes. What happened there? Give me a moment here. We'll get this going back again. One more time. Give me a second here. All right, there we go. All right. So, as we were saying, get back to where we were here. All right, so I think this is where we were here, right? Constitutionality. Jeez, sorry, I just got a little out of hand here. I think we're back here. All right. So again, this is a great list here. I'll bring us back up here. Proper presentation of alleged violation of the Constitution should include a discussion and analysis of one or more of the following non-exclusive criteria. I mean, this is not everything. Textual language, legislative history, pre-existing state law, structural differences, matters of particular state interest or local concern, the state traditions, and the public attitudes. So you want to have all this thoroughly documented because the courts can't be expected to search through that record. And again, failure to raise the issue of the constitutionality of a statute below will normally preclude it from a court considering the issue on appeal, but the court may sometimes decide to exercise its discretion to review an issue not raised below in exceptional cases or particular circumstances where the rule would produce a plain miscarriage of justice. Well, very rare, I would assume, but footnote 18. A defendant's contention that the term intellectual disability rendered a statute governing the crime of indecent assault and battery on a person with an intellectual disability unconstitutionally vague on its face would be reviewed on appeal only for a substantial risk of miscarriage of justice, where the defendant did not raise the issue in a pretrial motion to dismiss, which was the required procedure for a facial challenge based on vagueness. Wow. Interesting here. On a pretrial motion to dismiss. So as you can see here, a lot of these procedural issues here have to deal with before trial when we're talking about constitutionality. So on section 134, pleadings, briefs, and arguments on constitutionality of statute, raising constitutional issue by demurrer. It is fairly well established rule that the constitutionality of a statute may generally be raised by demurrer, may be generally raised by demurrer, at least in those states that have retained the demurrer as part of their procedural codes, although this is not necessarily considered to be the preferred way of raising constitutional challenges to the validity of statutes. The rule is more accurately stated as being that when a complaint states in form a cause of action resting upon a particular statute, the constitutionality of the statute may be raised by demurrer. So let's look at the practice tip here, see if we get some insight to this. Practice tip. Where this mode of attack is employed, under the rule adopted by some of the courts, it is not necessary for the demurrer to specify the particular grounds on which the constitutionality of the statute is attacked, a general demurrer being sufficient for such a purpose. Other jurisdictions require a specific allegation in the demurrer, stating how the law is repugnant to or in conflict with the Constitution. Wow. So we get 5 and 6 for that one. 5 is the behavior, the Beauvoir Club versus State in Alabama. And that's 1907, 1979. And then we have more recently the Wright versus State of Georgia, 1963. And it takes us on in section 135, the pleadings, briefs, and argument on constitutionality of statute, motion for summary judgment. Now we're on to pleadings and briefs and argument on that. Where a genuine issue of fact must be resolved before the constitutionality of legislation can be decided, a decision regarding the constitutionality of legislation will not be made on a motion for summary judgment. This is particularly true where the issue to be decided is one of first impression and is not clear-cut and simple. Conversely, where a decision is to be the constitutionality of legislation does not involve a finding on a genuine issue of fact, such a decision may be made on motion for summary judgment. Okay. But that seems... look at footnote 3. Hopefully we have something there. Nothing special on that, just... yeah. But let's see what we have here as the supplement on footnote 1. Although a sign company sufficiently alleged an injury for purposes of establishing standing to challenge a sign ordinance, a material issue of genuine fact existed as to whether its alleged injury occurred but for the unconstitutional provisions contained in the ordinance, or whether denial of its signed applications was based on independent constitutional grounds, precluding summary judgment in favor of the sign company on its claims for damages. Good. All right, so we're on to Section 136, which is admissions and stipulations as to the constitutionality of the statute. In any determination as to the validity of legislation by an admission, agreement, or stipulation, validity by admission, agreement, or stipulation, the principle should be kept in mind that the constitutionality of any act is a question of law for the court and not a matter of fact for a jury or for private parties to decide. This question affects the rights of the public generally, as well as the rights of parties to a particular proceeding. For this reason, courts should be careful not to declare legislative acts unconstitutional on agreed and general statements and without the fullest disclosure of all material facts, which takes us back to state customs. Stipulations that particular statutes of a state are invalid, as well as stipulations as to the steps taken in the passing of statutes and stipulations as to their construction, which in effect amount to stipulations of invalidity, are without binding effect. The principle that litigants, either specially or by admissive conduct, may not agree privately as to the constitutionality of the statutes has been expressed in the rule that a judgment of invalidity of a statute cannot be predicated on an admission. In other words, the court will not declare a statute to be unconstitutional because facts showing its unconstitutionality are alleged in the pleading of one party and admitted by the other. Okay. Parties cannot stipulate as to the law applicable to a given state of facts and bind the court. Thus, a stipulation on a particular provision of a constitution does not apply to the case, will not bind the court. Interesting there, too. The Supreme Court will not be bound by a stipulation regarding a statutory and constitutional interpretation. That was the Iowa Supreme Court. Constitutional questions will not be passed on in a friendly or fictitious suit, or on waiver of any other constitutional questions involved, or on the admissions of a district attorney. Oh, wow. Or on agreed statement of facts. So this is a way of, I guess, not bringing in constitutional questions after it's been agreed upon one course of action for a case. Parties cannot stipulate to a particular construction of state law and thereby obtain jurisdiction over an appeal to the Supreme Court where the state law might, in fact, be in harmony with the federal Constitution. The Supreme Court's jurisdiction is properly invoked only when a court of appeals has squarely held that a statute is unconstitutional on its face or as applied. Or as applied. Important language here. A statute is unconstitutional if not just on its face or as applied. And jurisdiction does not lie if the decision might rest on other grounds. A stipulation or consent judgment declaring a law unconstitutional is not valid. Okay? See here, a party may not compel a court to decide a constitutional argument, especially one of some difficulty, by stipulation. A party may not compel a court to decide a constitutional argument by stipulation. And regardless of what the parties may have stipulated, constitutional provisions are defined by the court. And then we have Section 137, standing to challenge constitutionality of the statute, generally. It is always open to interested persons to show that the legislature has transgressed the limits of its power. So it is always open to interested persons. And persons injuriously affected may question the validity of a law. No statute can be insulated from attack on its constitutionality, so long as the action is brought by a challenger with standing. The nation's courts are open to injured individuals who come to them to vindicate their own direct personal stake in our basic charter. And an individual can invoke a right to a constitutional protection when he or she is harmed, even if the broader public disagrees, and even if the legislature refuses to act. And here's our practice tip. In order to establish standing to challenge a law as unconstitutional, an attorney generally must show that his or her client has suffered an actual or threatened, distinct, and palpable injury. There is a fairly traceable causal connection between the injury and the defendant's challenged conduct, and there's a substantial likelihood that the requested relief will redress or prevent the injury. So, to establish standing, here's what we need to do. Attorney General must show that his or her client has suffered an actual or threatened, distinct, and palpable injury. There's a fairly traceable causal connection between injury and the defendant's challenged conduct, and there's a substantial likelihood that the requested relief or redress will prevent the injury. So, standing is a prerequisite to challenge the constitutionality of a statute. Even though a statute is unconstitutional, only those who have a right to raise a question of its unconstitutionality, that is, those who have standing, may invoke the aid of the courts to have it judicially set aside. For a litigant to have standing to challenge the constitutionality of a law, the law must be unconstitutional as applied to him or her. As applied again, and one whose rights are impaired by a statute can raise a question of its constitutionality only as applied to him or her. As applied again. The standing requirement is a limit on the court's jurisdiction, which restrains the judiciary to resolving real controversies, cases and controversies in which a complaining witness has a demonstrable injury. They can demonstrate to the court with a causal connection between that injury and that alleged conduct. Only members of a class whose constitutional rights are endangered by a statute may ask to have it declared unconstitutional. Of a class. Before a law, let's look at number 12 here real quick. (2019), pretty current. Before a law can be assailed by any person on the ground that it is unconstitutional, the person must show that he or she belongs to a class in which has an interest in the question in the enforcement of the law would be an infringement on his or her rights. The party asserting a constitutional challenge must demonstrate standing at all stages in the litigation, even prior to trial, and the plaintiff must be able to show that he or she has been harmed at the time the complaint is filed, alleging a constitutional violation. As a general rule, a litigant has standing to challenge the constitutionality of a law only if the litigant's own rights are impaired or adversely affected or impacted by the law, or if he or she is about to be adversely affected or assuredly will be adversely affected. Other authority holds that to have standing to challenge the constitutionality of a statute, the plaintiff must demonstrate a realistic or immediate danger of sustaining an injury or direct injury as a result of a statute's operation or enforcement. Here's our observation. While some authority holds that to establish standing to challenge the constitutionality of a statute, a party must have suffered some injury under the statute that unconstitutionally restricts the party's own rights. Other authority holds that the legally protected interest at issue need not rise to the level of a right, let alone a constitutional right, but rather a party challenging the constitutionality of a law need only demonstrate that he or she has a legally cognizable interest that has suffered because of the state's action. Let's see here, number 24 real quick. If it's anything else besides citations, and it's not. All right, I don't think we have any more here. No. Okay, so let's get back, finish up our section here. Standing rules are not to be applied mechanically. Apply to all cases at law and in equity, to attacks on ordinances, and to criminal proceedings. A federal court standing inquiry is especially rigorous, where reaching the merits of a dispute that would force the court to decide whether an action taken by one of the other two branches of the federal government was unconstitutional. The corollary to the general rule is that one who is not prejudiced by the enforcement of an act of the legislature cannot question its constitutionality. A party cannot challenge a statute's constitutionality when the claimed defect does not apply to that party, absent a showing of injury, actual or threatened. There could be no constitutional argument. Ordinarily, if a statute is not unconstitutional as applied to the litigant who brings the claim, the litigant has no standing to argue that the statute is unconstitutional on its face. As a general rule, where a proceeding directly involves only one section of an act, it is not necessary to consider, and a court should not decide, questions raised as to the constitutionality of other provisions of the act not directly involved in the proceeding. That a plaintiff has standing to challenge one of the statute's provisions does not mean the plaintiff has standing to challenge all of them. So provisions of the statute are taken individually, not collectively. Severance of particular statutory provisions to limit standing promotes important goals, notably the avoidance of unnecessary constitutional adjudication and the sharpening of legal issues facing the court. Ooh. Practice tip. In assessing a plaintiff's standing, the court assumes that the plaintiff will prevail on the merits of their constitutional claim. Wow. So here's our cumulative supplement here, too, which is nice. We have cases. The voting rights organizations had standing to bring action challenging new redistricting maps as violating the North Carolina Constitution based on partisan gerrymandering. Organizations each sought to vindicate rights enjoyed under the North Carolina Constitution. Each had members who would otherwise have standing to sue in their own right. The interests each sought to protect were germane to each organization's purpose, and neither the claim asserted nor the relief requested required the participation of individual members. That sounds kind of fishy. There's 2022 North Carolina. A subcontractor was not awarded the guardrail portion of the federal highway contract as a result of the contractor's subcontractor compensation clause, offering financial incentives to a prime contractor for hiring a disadvantaged subcontractor, had standing to seek forward-looking declaratory and injunctive relief against the future use of such compensation clauses on equal protection grounds. Interesting there. That's Connecticut. The irreducible constitutional minimum of standing contains 3 elements. Here we go. 3 elements for minimum of standing. Injury in fact, a causal connection between the injury and the conduct complained of, and the likelihood that the injury will be redressed by a decision in the plaintiff's favor. Petitioner, who was gathering signatures to place an initiated measure on the ballot, lacks standing to challenge the validity of a statute governing initiative, referendum, or recall petitions. Oh, shoot. Give me a second here, one more time. Darn it. Come on. It's going to give me a hard time here, huh? Give me a second here. Oh, here we go. Come on. Well, we're just about wrapping it up anyways, but let me just get us back up here so we can That's really odd this happened here, huh? Give me some moment here and see if we get this back up. Huh. One more moment here. There we go. All right. So where we left off here, because I just want to finish up these footnotes here before we go any further here. There we go. Demurrer. General demurrer petition. Okay, we went through these. A declaration based upon violation of an invalid municipal ordinance is legally sufficient upon demurrer. All right, and this is where I think we left off here on. Good Lord. There we go, standing, finally. All right, thanks for sticking along, and let's get back to this footnotes where we left off. Petitioner, we got that one. Place a measure on the ballot was in fact acquired by the applicable deadline. Let's read this again. Petitioner who is gathering signatures to place an initiated measure on the ballot lacks standing to challenge the validity of a statute governing initiative, referendum, or recall petitions where the petitioner failed to show that if the statute were unconstitutional, the number of signatures needed to place the measure on the ballot was in fact acquired by the applicable deadline. Wow. Okay, that makes sense. In order to have standing, a party challenging the constitutionality of a statute must show a direct and personal harm resulting from the alleged denial of constitutional rights. It's Minnesota, 2019. Blumenthal versus Trump, 2020. That's on 29. It's a standing and pre-enforcement challenges. Court will not declare a statute unconstitutional when the party challenging the validity of the statute is not harmfully affected by the particular feature of the statute alleged to be constitutional. So if you're not harmfully affected, then there's no standing there, it looks like. Or they won't declare the statute unconstitutional. As to exceptions to this rule, okay, that's all those. And the last one I want to double check on was the one here, Blumenthal versus Trump. And that's footnote 29. What was that referring to here? All right. A federal court standing inquiry is especially rigorous when reaching the merits of a dispute that would force the courts to decide whether an action taken by one of the other two branches of the federal government was unconstitutional. Okay. All right. Good stuff. So we'll leave off here our section 138 for the pre-enforcement challenge to constitutionality of a statute because we've gotten through the gist of it here. And with that, we've got a better view on what we would consider the declaratory judgments and ways of approaching disputes with the constitutionality of particular statutes. So let's double check on the chat here and see if there's anything left behind. And we have Two Cups here says, it all depends on the way you question jurisdiction. What did you do in order to question jurisdiction properly? And that was in response to this one of St. Frog Dog. The judge involved refused to force a prosecutor to prove jurisdiction. So yeah, interesting questions when it comes to that. But again, The important thing here is the constitutionality of the statutes or ordinances and how they're applied. And in that respect is where we want to kind of get the knowledge here to know that there's a proper time and place and manner in which to address these contentions, and that the Constitution is the supreme law of the land and stands above all of these statutes, codes, and ordinances. And whenever there's a particular violation or encumbrance upon the people because of these statute, codes, and ordinances, then it's our due diligence, it's our duty to bring them before the courts so they can be corrected and redressed appropriately. Well, with that being said, I want to appreciate everyone for coming here and sticking with it tonight. It's been a long and definitely a densely information-packed presentation. I learned quite a few details here. We learned a few extra words along the way and pronunciations. I want to appreciate everyone for being here tonight. I know there's a lot of other more interesting things to do, but I find things that are applicable in our daily life and expanding our engagement in freedom and liberties is to be the most mentally engaging. So with that being said, salute to you all for being here, and I'll see you all on the next one. Salute.